Attorney General.
Thank you, Mr. President. I beg to move that a bill entitled An Act to Amend the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Mr. President, the Administration of Justice, Indictable Proceedings Act 2011, Act number 20 of 2011, is an act that we have spoken to often in the last 8 months or more. It is an act, as we know, which has, from proclamation, abolished preliminary inquiries and introduced a new system by which summary and indictable matters are to be accomplished in a more expeditious manner. One of the material sections of the Indictable Proceedings Act, which I will refer to for convenience as a JIPA, is Section 33 of that Act, which provides 33(1), the Indictable Offences Preliminary Inquiry Act and the Indictable Offence Committal Proceedings Act 2014 are repealed. 2, notwithstanding subsection 1, the Indictable Offences Preliminary Inquiry Act shall continue to apply to proceedings which were instituted prior to the coming into force of this Act, where no order is made under Section 32A. The consequence of that a JIPA Act having therefore been proclaimed is that preliminary inquiries, save in the limited respects to which they are saved by that Act, come to an end. We have, however, Mr. President, the Extradition Act, and by Section 12 of the Extradition Act, that is provides, 1, a person arrested in pursuance of a warrant issued under Section 10 and in respect of whom no order under Section 11(2) has been made, shall, unless previously discharged under Section 10(3), be brought as soon as practicable before a magistrate. 12(2). For the purposes of proceedings under this section, a magistrate shall have the like jurisdiction and powers as nearly as may be, including power to adjourn the case and meanwhile to remand the person arrested under the warrant, either in custody or on bail, as when the magistrate is acting at a preliminary inquiry. So we are faced with a situation which has been brought to my attention, Mr. President, because there are actually a couple of cases in the Magistrates' Court now in which the point has been taken that because the JIPA Act has repealed the Preliminary Inquiry Act, the magistrate has no jurisdiction under the Extradition Act to function as if acting at a preliminary inquiry. It is arguable that that is not the case and that the Extradition Act stands on its own, and arguments are currently being made in the courts to that effect, but it is equally arguable that a magistrate may not purport to exercise preliminary inquiry functions because that jurisdiction has been repealed by a JIPA. We cannot take the chance of that lacuna continuing to exist, given that there are pending proceedings before the court in which fugitives who are about to be extradited could succeed in persuading the magistrate on an argument that the magistrate has no jurisdiction to have them before him or her. And for that reason, Mr. President, we have brought before this chamber a one-paragraph bill, that is to say, the bill before the House this evening, to amend the JIPA Act. And by clause 3 of that one-paragraph bill, we wish simply to add 2 further subparagraphs to the section that I've already read, section 33. So clause 3 of the bill says, Section 33 of the Act, that is to say the AJIPA Act, is amended by inserting after subsection 2 the following subsections. That is to say 3, notwithstanding subsection 1, and that is the section which repeals AJIPA, and section 35(2), the Indictable Offences Preliminary Inquiry Act shall have effect for the purposes of the Extradition, Commonwealth, and Foreign Territories Act. And 4, subsection 3 is deemed to have come into operation on the 12th of December 2023. That is the date on which AJIPA was proclaimed. So in summary, Mr. President, we are asking this chamber on an urgent basis this evening simply to save the continued function of magistrates under the Extradition Act by passing the amendment to Section 33, which I've just read, and that is to say, notwithstanding the repeal of the AJIPA Act, of the Preliminary Inquiry Act, the magistrates shall continue to have jurisdiction for the purposes of the Extradition Act under that Act, and therefore we are saving the continued operation of the Preliminary Inquiry Act from December to continue to be exercised under the Extradition Act. And I don't think I need to explain it in any further detail, Mr. President, and therefore in those circumstances I beg to move.